welcome to Sahara TV, where we're looking at the major topic on the front burner of the national issue. Yesterday, we saw the National Assembly approve the declaration of the state of emergency in Rivers State. Before we talk about the National Assembly, let's just have what was your initial reaction to the declaration of the state of emergency by President Bola Tinubu?
I have had the privilege of making my position widely known through the media houses who had sought my view and interviewed me on that subject matter. And we came to a fairly clear position. First is that the President of the Federal Republic of Nigeria and the Commander-in-Chief of the Armed Forces, Senator Bola Ahmed Tinubu, he operated within his right to declare the state of emergency. And that is pursuant to his powers under Section 305 of the Constitution of the Federal Republic of Nigeria as amended, 1999 as amended. What we did not agree with, and in respect of which we have made our views elaborately clear, is the suspension of the governor and members of the State House of Assembly, which, by the way, are arms of government. In the same way, he constitutes an arm of the executive arm of government. He superintends the head of the executive of the government of the Federal Republic of Nigeria. Even from that standpoint, it is incongruous to imagine that the one could suspend the operation of the other. In fact, as a lawyer, I can tell you that the judiciary hardly does that. The judiciary cannot, as it were, put a stop or halt the performance of the function of any other arm of government, executive, legislature. What they can do, what the judiciary can do, is to intervene in the propriety or otherwise of the performance of that duty. But they cannot say you should not, because it's an arm of government. In the same way that President Bola Ahmed Tinubu was elected as the President of the Federal Republic of Nigeria, that is the same way that Governor Fubara, similarly Fubara, was elected. So from that perspective, we condemned it, and were able to point out that within the limit of the law as presently constituted, he lacks that power. And if you look at the express provisions of Section 305, as it is with every other section of that Constitution, you will find that not in one provision of that Constitution, no less the one under review, Section 300, or any other provision of the Constitution for that matter, is he vested with the power to suspend any democratically elected state actor. He lacks that power, and that should be clear enough. Mark you, I have continuously used the word suspend, because that is what he did. In fact, he couldn't have removed, because the provision for the removal of a governor is contained clearly under Section 188, and the president has no role to play in that. So, if we speak of constitutional democracy, and if we mean federalism as a system of government, organizing a heterogeneous society with diverse culture, language, general diversity of a people, what it means in political philosophy is that it recognizes juxtaposition of state powers at different tiers of government. In fact, they are autonomous. But expected to cooperate, in delivering the dividends of democracy as the general pattern of governance. So you cannot be in Abuja and deny me my civic right to enthrone leadership within the federating units of Nigeria. That is at the core, at the heart of this debate. So, make no mistake about it, with respect to declaration of the state of emergency through proclamation as required by the Constitution, the president was within his rights. With respect to the consequential action that he took, believing that that was the best way to salvage the situation, understanding the trajectories of development that led to that point, I'm afraid he missed it.
I think looking at the legal limitation, the constitutional limitation of the president in suspending the governor and deputy and the House of Assembly of River State. And as it is now, the National Assembly has approved this declaration and suspension by the president. And we want to ask, what legal weight does the process of the approval using the voice votes? We were not sure whether they reached a quorum as stated in the constitution. What legal weight does this carry, and can this process be challenged in court?
Mm. Well, thank you for that question. Um, let's look at it from two angles. The one is, how does the National Assembly operate? And the other is, how does their operation impact on the people of this country through, in parentheses now, the representation that they ought to offer? I think under Section 60 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, they reserve the right, I'm talking of the National Assembly now, to make rules by which they operate. The same thing is applicable to the judiciary. Every court, up to magistrate court, has the right to make rules of its court. 2019 Federal High Court rules, 2009 High Court of Lagos State, and so on, and so Supreme Court rules, Court of Appeal rules 2021, and so on and so forth. So you could see independence and autonomy within the arms of government. Pursuant to that, the rules of the Senate as well as the House of Representatives mandate them to define the processes of engagement with respect to exercises such as this. But the issue is, to what extent is that rule materially important and effectual in the face of the express provision of the Constitution, knowing that the Constitution itself is not just supreme, it declares itself to be paramount above every other law, and says in section 1 subsection 3 that if any other law, whether rules, legislation, or whatever, regulation, practice, direction, comes in conflict with the express provision of the Constitution, that other rule, that other regulation, that other whatever, shall, to the extent of that inconsistency, remain null and void. So, the Senate may have made rules empowering themselves to do what they have done. The Constitution, recognizing that this is a very sensitive and profound operation of government, state of emergency is almost a perversion. It's almost an aberration that could lead to a travesty if not done within the ambit of the law. And that's why we are complaining. And it is urged that it should be used seldomly, sparingly. And you must do it within the powers of the law, within the dictates and provisions of the law. Which is why it envisages that if you do not check the powers of the president in the exercise of this function, the tendency is that you will harvest the reality that power corrupts and absolute power corrupts absolutely. Many people have refused. And their refusal is not unfounded. Now, this is not a purely legal matter. This issue is steeped deeply in politics, looking at 2027 and the fate of Rivers State as a crucial state in the federation of this country. One that has enormous political economy. There's a political economy angle to this whole thing. And therefore, made it an additional condition that whereas Mr. President can declare through mere proclamation, gazetting the proclamation, once he makes that declaration shall be gazetted in the Gazette of the Federation and immediately transmitted to the leadership of the Senate and House of Representatives, the President and Speaker respectively, who shall, within 2 days if in session, rectify. That's the one you call approval. And where they are not in session, reconvene necessarily within 10 days. The purpose is to say, has the president met with the conditions stipulated under section 305, subsection 3, that lays down the conditions and the parameters that must exist before you declare? What are these conditions? That the country or any part thereof, including Rivers State, must be at war. We know the meaning of war. He didn't say when there is isolated pipeline vandalization, sporadic shooting in isolated part of the state. When there is imminent and present danger of war, or if the federation or any part thereof has been levied with war by an external aggression, if there is national or natural disaster enough to compromise the peace and safety of the country or any part thereof, and so on and so forth. The question is, did those conditions exist before you and I who live here? I'm not talking about people who are in diaspora. Yes, the president is entitled to security reports and the dimensions of security activities, even threats. But in my view, as a very close watcher of events in this country for very many decades now, I do not think that what has happened in Rivers State can be equated with what happened in Lagos State, when the entire arm of legislative government was seized, practically speaking, in such a manner that they could not function, at least to the extent that we witnessed. Forget about the undercurrent waters I went to, but it was resolved. Now, the Constitution allowed the president to exercise that discretion to be able to actualize constitutional democracy. The whole idea of constitutional democracy through representation is to guarantee checks and balances. That check ought to come from the legislature, either at the parliament, at the federal level, or within the federating states. Ours lost the steam. They could not rise to the occasion to even interrogate whether those conditions existed, let alone making the processes transparent enough to allow those who are represented to assess. They are not there on their own. They are there representing you and I. It would have become our judgment that our senators, our House of Representative members have come to this fair conclusion, which is not radically different from what we think and what we feel. The people of Nigeria did not fail on this call. The people of Nigeria rose in unison, at least in public engagements. From that day till now, I have not rested. Even while in court, there is no major media house that has not reached out to me in person, and I have responded. And all of those speculated. They went around in building the opinion of the Nigerian people to say that this is not one of such instances when you declare a state of emergency. Secondly, when you declare this state of emergency, you are not empowered by law to dismantle democratically elected or constituted bodies. Now, given the configuration and the maturity of our democratization efforts, what we saw was that check and oversight for which the legislature exists appear to have come to naught. There was no opposition. The few oppositions we could see were muzzled to submission. So much so that what was made known to the public was the Hallelujah chorus that they wanted the world to see in upholding what it is that Mr. President has done. That for me was a serious disservice to the country. But what was more important, the lack of transparency by which they conducted the affairs of the assembly, talking about the National Assembly this time, left so much to be desired. And what do I mean? With respect to such a critical development in our country, and given that we were at a critical curve and turn, we needed to know what the disposition of our representatives were, who supported what, and for what reason. We were denied all of those through the voice vote. It was possible that there could be some men of conscience in that assembly who would have loved to toe a different line and who would have been able to persuade their colleagues. Because remember that this was an exercise that was supposed to come to an end within 48 hours. The first day, they were almost unable to organize themselves. And if they had that critical sitting on the second day, they would have been very thorough and robust debate along the issues before coming to that conclusion. All of those were lost in the voice vote that usually ridicule all that we do in the National Assembly. So, back to your question directly, it is that the law gives them the right to set their rules. It is left to them to know whether they have satisfied what the law requires them to do, whether it must be in all cases that you go by way of vote, or whether the people of this country reserve the right to also know, to be able to form their opinion, knowing that democracy is a journey. It's not a destination as such. It's a journey. And we can only acquire the um, the instrument of assessing this journey if we know how the operators of the democracy are behaving. And this is one of such occasions when we didn't know and we cannot determine. So, you see, the executive has misfired, the legislator has misbehaved. If you ask me, what would have been ideal now is that Fubara, even members of the State House of Assembly, proceeds to the court to contest
Yeah, so that was what
to contest
that's what we are going to
the
come
propriety of
and
what has happened.
to ask, do you think, do you have a confidence that the judiciary, which is like the last hope on this matter, would sort of overturn and not use technicalities to throw away the case, as we've seen in judicial precedents, saying that the the just use the judicial precedent to throw the case away on technical ground and not overturn this matter. What's the confidence in
You
the
know,
judiciary?
it has all. Look, I'm a trained lawyer, and some of us are not just lawyers. Go and check our activities, even in the university, trying to acquire this law. So I have no option other than to continue to fight, eh, and deepen the the judicial practice in this country, knowing that that is but the only option left for a people such as ours in the political mix as we have it presently. If we do not have the judiciary that we desire now, it is our responsibilities as operators in that circle to continue to push and expand the frontiers of the debate and make interventions concrete enough to be able to get to where we have to get to. Because the fact that uh, the fact that we don't have what we want at the moment does not dislodge the logic that it remains our best option as a committee within the civilized nations of the world. If you discountenance that, you come in direct confrontation with anarchy. And like my people say, when you carry water and carry wine, you will know the one that is heavier. Some of us have gone through both of them. So, having cleared that point, it is that you may not know. In short, even the law is what it is, as pronounced by the court. Those of us who go to court to ask critical questions, we seize the law as an instrument to drive social change. We deploy the law to set the tone and target at some end that will change or bring about a change in the way things are done. When you do your part, you leave it to the other to crystallize it. In those days, when we witnessed the golden age of the judiciary, it was not in all the circumstances that people thought that the judiciary will rise to the occasion and do what they did. The case of Governor of Lagos State and Ojukwu, where it took profound minds like Chukwudifu Oputa, Justice Anegolu, Obaseki, Kayode Esho, those were the Nnamani, those were the golden era as described by our hero and past boss, Chief Gani Fawel. You cannot rule out that there are still such. We practice law. We know. Forget about what people say. We know very incorruptible judges in this country. We know very hardworking judges in this country. We know those who will declare the law, let the heavens fall. And they cannot optimize and maximize what they have in them if situations such as this are not brought before them.